Good afternoon, distinguished justices, judges, and all environmental law experts to the launch of the Judicial Masterclass series. In this session, we have simultaneous interpretation available in Chinese, Thai, and English. And if you would like to hear either the Chinese or Thai channel, please click the interpretation button and select the channel that you would like at the bottom of your screen. Thank you very much for joining us again for this session. My name is Georgina Lloyd, and I'm the Regional Coordinator for Environmental Law and Governance at the Asia Pacific Regional Office of the United Nations Environment Programme. In this session, we are going to hear from two speakers and my close colleagues at ADB, Christina Pak and Briony Eales. They are going to speak to our collaborative work on judicial capacity building. And then, of course, we'll move into the launch of the Judicial Masterclass series. First, we're going to hear from Christina Pak. Christina is the Principal Counsel of the Asian Development Bank and is responsible for managing the Office of General Counsel's Law and Policy Reform Program, which designs, processes, and implements technical assistance projects directly to developing member countries related to legal and judicial reforms. She oversees a diverse portfolio in the areas of environmental protection and climate change, gender equality, private sector development, public-private partnerships, and the digital economy. Our other speaker, our second speaker after me is going to be Briony Eales, who is, of course, an environmental, social, and governance lawyer. And she's also the team leader for the Asian Development Bank's Environment and Climate Change Law Judicial Capacity Building Program. This program supports judiciaries in Asia and the Pacific to strengthen their knowledge and procedures for environmental and climate change law adjudication. So I'm first going to give the floor to Christina for her remarks. So first, thank you, Christina. Over to you.
Thank you, Georgie, for that kind introduction. Really appreciate it. And it's always nice to organize these events with our development partners. A warm hello. I'm here in ADB headquarters in Manila. Honorable Justices, ladies and gentlemen, really appreciate you joining us. I have to say it's been an exciting day for us today at ADB with the focus on judges, which is crucial to our work under our Law and Policy Reform Program. Of course, I'm also excited to welcome you to this launch of our Judicial Masterclass program. It's a new initiative in collaboration with our long-standing development partners, the UN Environment Program and USAID, Reducing Demand for Wildlife. So perhaps first I can give you some background on our work, along with our inspiration for creating the Judicial Masterclass program. So, over the last decade, since ADB started working with judges on strengthening the environmental rule of law, ADB, UNEP, USAID, we've been assisting courts across Asia and the Pacific with more effective and efficient adjudication of environmental and now, emerging complex climate change cases. We engage with chief justices and the senior judiciary because we recognize that they influence legal systems and environmental enforcement directly and indirectly. Perhaps the most satisfying outcome of our respective programs is the enhancement of environmental and climate change jurisprudence. So over the years, various courts in the Asia Pacific region have made significant progress with environmental law adjudication and administration, led by champion chief justices and high court judges. For instance, you've heard the Pakistan Supreme Court Justice Aisha Malik mention the Laghari and Pakistan case, which is seminal, and it's actually cited as a precedent even beyond Asia. Another example is a recent court decision in the Bangladesh Supreme Court, Bella versus Bangladesh, that deemed wetland conservation essential for humankind survival, given that wetlands purify water. As Bangladesh is a party to the Ramsar Convention, the court held that the government is legally obligated to immediately formulate a national policy and pass a law for wetland protection. There are other orders that also demonstrated the court's awareness that all sectors within Bangladesh must act in harmony and mainstream ecocentric approaches within development plans. For example, the court stressed the importance of moving Bangladesh to 100% renewable energy generation. So these seminal decisions have been made possible with the sustained engagement with and between Asian and Pacific judiciaries. But of course, because of their incredible hard work and dedication of these judges as well. A central feature of our support to judiciaries has been the creation of the first of its kind platform called the Asian Judges Network on the Environment. It's a dynamic platform for judicial capacity building and multilateral exchanges for environmental adjudication. And so we started with judges from the Southeast Asia and the South Asia. And in 2018, we expanded our network to include South Pacific judiciaries, and now working to engage with judges from Central Asia. However, for the last 2 years, the COVID pandemic has made it very challenging to bring judges together. Travel restrictions and the deadly pandemic made face-to-face conferences impossible and significantly impacted our programs and the connectedness of judges in our region. We believe that these connections and informal exchanges are absolutely essential. They create formal and informal opportunities for judges to discuss with each other's cases, share principles applied and challenges overcome. So questions such as, how did you manage standing in this case, have allowed judges to share ideas and judicial problem-solving techniques, as well as expand their judicial skills. Without these conferences, UNEP, ADB, USAID have found it difficult to replicate this judicial exchange that we know is invaluable. At the same time, many of you know all too well that our region has many serious complex environmental and climate change challenges, which the COVID pandemic has worsened. Lockdowns diminished regulatory oversight, allowing environmental degradation, pollution, illegal activities to increase. In fact, it's been reported by the IPCC and the IPBES last year that this is the situation, and the COVID stimulus packages have not really prioritized green solutions. So economic recovery risks harmful knock-on impacts. So with this background, last year, ADB, UNEP, and USAID started discussing how we might jointly innovate in judicial capacity strengthening and exchange. Our starting point was simple. What if we could bring judges together in small virtual workshops to do deep dives into prominent and cutting edge Asian and Pacific jurisprudence, such as those 2 cases I mentioned, among others, with judges who wrote these decisions. Such workshops should be small, so everyone can participate, but apply the Chatham House rule to protect the participants. Moreover, such a concept must be simultaneously helpful to the judges to hone their skills and allow them to maintain and build their network of peers. So we are here today with all of you to launch our Judicial Masterclass series to enhance judicial learning and networking this year and hopefully beyond. So these workshops will be open to judges only, and we will start with a limited number of 4 classes to pilot them to make sure that the initiative works and it is useful. So before I turn over to my awesome colleague Briony, who's been the driving force behind our work with the judges, I would like to end by thanking our partners in this initiative, UNEP and USAID, Reducing Demand for Wildlife, as well as all of you for tuning in and contributing so much towards our collective efforts towards sustainable development. At ADB, we very much embrace collaboration with our development partners, which allows us to brainstorm and build more diverse ideas and harness our collective resources to do something dynamic and to ensure that we do not bombard judges with different versions of the same thing. So thank you so much for working with us on this initiative. We are tremendously excited to work with judges to build a model for judicial engagement that allows for their continued networking in the post-COVID working environment. an environment that integrate both face-to-face and virtual interactions. So much more can be possible. So thank you again for joining this launch. And Briony, the floor is yours. Thanks.
Thank you so much, Christina. And just before we hand over to Briony, I'm going to build a little bit further on the fantastic introduction that Christina has provided, and just give a little bit more context into the rationale and the reasoning behind the launch of this, as Christina said, this innovative new approach that we're piloting for judicial capacity building. So let me first start by sort of saying, why of course are we doing this? And we've heard over the last 2 days about some of the challenges that we continue to face, particularly the triple planetary crisis. This is a nature crisis linked to the collapse of biodiversity, where we're losing species at the rate of 1,000 times more than at any other time in recorded human history. This is a pollution crisis, where we have a crisis of air pollution. We also have contaminated water. And finally, this is a climate crisis. And we know through the increasing frequency and magnitude of extreme weather events, through the sea level rise, food shortages linked to ecosystem loss, and many others. And so together with our partners, we need to address the triple planetary crisis through sound environmental governance. And this looks at the rules, policies, and institutions that are really shaping how humans are interacting with the environment. Specifically, promoting the environmental rule of law is a key aspect of our work around environmental governance. And judges at all levels, from first instance trial judges to Supreme Court judges, are really critical for environmental rule of law. Judges are the custodians of rule of law. And so we're going to look at this from an environmental lens. So when we talk about environmental rule of law, what we mean is this integrates environmental needs with the essential elements of rule of law, and it provides the basis for improving environmental governance. Environmental rule of law is providing a foundation for environmental rights and obligations to be exercised. Because without environmental rule of law, the enforcement of legal rights and obligations and environmental governance can be discretionary, subjective, and unpredictable. In 2019, UNEP released the first ever global assessment of environmental rule of law. And this found that weak enforcement is a global trend that is exacerbating environmental threats. And this is despite the prolific growth in the number of environmental laws and environmental agencies worldwide over the last 4 decades. Based on the global analysis, it found that despite a 38-fold increase in environmental law put in place since 1972, a failure to fully implement and enforce these laws is one of the greatest challenges to mitigating the triple planetary crisis. So climate change, pollution, and species and habitat loss. So whilst environmental laws have greatly increased, it is often the implementation and enforcement of those laws that falls short. So to address this, UNEP, together with ADB and USAID, we're focusing on strengthening institutions, building strong, transparent institutions through capacity building support to really ensure efficient implementation of environmental laws. Our work with the judiciary is a really critical part of this mandate. Effective judicial institutions are critical components of the environmental rule of law. In turn, of course, environmental rule of law is critical for the protection of the environment and the promotion of the right for all of us to live in a safe, clean, healthy, and sustainable environment. So the judiciary we see as a really central institution, promoting environmental sustainability through its enforcement of environmental law and the delivery of environmental justice. Because without this, without proper judicial interpretation and application of the law, even the best and the most comprehensive of environmental legislation could be futile. And we've also seen that judges at the national level are increasingly being called upon to both understand and incorporate nationally accepted principles of environmental law and to uphold environmental rights in their judgments to effectively adjudicate environmental matters. So building on the foundations of the work that we have done to date, we seek to build the awareness of all judges, and this is essential to really tackle the triple planetary crisis. Over the years, ADB, UNEP, and USAID have facilitated platforms and forums that enable judges to exchange information and experiences, which Christina mentioned we see as essential. And of course, there have been a number of publications that have been released to support the work of courts and the work of judges. And Briony also mentioned the ADB publication on climate change coming to a court near you. In addition to the publications, ADB has also supported the Asian Judges Network on the Environment and held forums at the regional level and sub-regionally since 2012. UNEP has also supported similar global forums, including the World Judicial Conference on the Environment, which was held with the Supreme People's Court of the People's Republic of China in Kunming in 2021. And this actually culminated in the adoption of the Kunming Declaration, which advances normative standards and sets collective tenets for the judiciary in environmental adjudication. The declaration echoes that judges are key in addressing the environmental crises, in upholding environmental and climate justice, and of course, the right to a safe, clean, healthy, and sustainable environment. Also, in addition for ADB and UNEP sharing judicial opinions and thinking around the world, also USAID has worked with the Supreme Court of Thailand through holding the Asia Pacific Judicial Symposium on Best Practices in Environmental Courts and Adjudication. And as we said, this enables that informal exchange of ideas between judges. And it was found in the 2019 Environmental Rule of Law report that peer-to-peer exchange and access to decisions from sister courts can significantly increase the number of environmental cases that are heard. We also have the Informea platform, which is an online access to training materials. So we have developed a number of judicial capacity building programs, including working together with USAID to develop a course with the Supreme Court of Thailand, supporting its efforts to take on a leadership role in the region in environmental rule of law since it launched its program in 2016. An inaugural judicial roundtable on environmental adjudication, rule of law and environmental justice was held in 2019. And we've also then led the introductory course on on international and national environmental law and governance. And this was also done closely with the Judicial Training Institute of Thailand. USAID's Reducing Demand for Wildlife continues its partnership with the Supreme Court of Thailand. And UNEP also is continuing to support this to really help the Supreme Court of Thailand take on its leadership role in the region. This is a link to the introductory course that was launched for judges in Thailand, and it's comprised of 10 lessons that include online learning, in-class tutorials, and lessons that review a number of different topics, and it can be conducted in person or virtually. It's really the first of its kind of course that was developed by with the Judicial Training Institute of Judges. And we had over 50 judges who participated in the inaugural launch of this training, which was held over 5.5 days in May 2021. We also have the Global Judicial Portal, and this provides access to decisions and other resources for judges by judges. And you can see the link to the portal here on this slide, judicialportal.informea.org. This includes a compilation of a number of landmark cases, and it's possible to also add additional cases to the Global Judicial Portal on a rolling basis. In closing, let me iterate that judicial capacity building and our ongoing support for judicial institutions is a really high priority for UNEP and our development partners. And Christina also underscored this, because we recognize that a fair, transparent justice system that efficiently resolves natural resource disputes, upholds environmental rights, and enforces environmental law is critical in establishing the lasting environmental rule of law. So we're really delighted through the partnership to launch this new element of our judicial support, which of course is the Judicial Masterclass series. So thank you very much for that. And I will now hand over to Briony to introduce the Masterclass series to everyone.
Thank you, Georgie. And so again, honourable justices, participants, welcome to this launch of the Judicial Masterclass program. And I reiterate both what Christina and Georgie said about the importance of partnering with judiciaries and supporting them. And again, ADB is so delighted to partner with United Nations Environment Programme and USAID Reducing Demand for Wildlife in launching this new concept. So let's talk about the who, why, what, where, and where. And Angelo, could you please start my slide deck if you have it there? Sorry, everyone, we're just waiting for the slides.
Hold on, please.
But let me start as while Angela's loading the slides. You know, for the last decade, what has been central to the program has been that ADB, UNEP, and RWD have run programs in Asia and the Pacific and beyond around the adjudication of environmental and climate law. And so typically these programs have used in-person judicial conferences, colloquiums, and workshops, which bring the judicial community together for knowledge sharing and networking. And sadly, the COVID-19 pandemic and its many tragedies halted these face-to-face events, shifting them online. And these online programs have been great, but they haven't quite succeeded in replicating the intimate nature of in-person workshops. So those workshops allow judges, as Christina said, to ask each other, questions about how did you do this? How did you manage that? And they promote this informal but valuable exchange, and moreover, a sense of community. And that community allows for honest and sincere conversations and the emergence of professional friendships. And we all know the value of professional relationships. We all know that it is much easier to reach out to someone that you know, someone you've met at a conference, to share ideas, share challenges, and just ask how somebody else has managed something. And so these workshops are designed to replicate that more intimate learning and networking environment. Next slide, please. So who's it for? This program is for the judges of Asia and the Pacific. And as Christina said, when we were trying to ask ourselves, next slide, please, Angelo, what is it that we could do to replicate these intimate learning environments? How do we make online learning more engaging and interactive? Absolutely no criticism to online webinars. We're in one, but they can get a bit tiring and they can lack the capacity for this face-to-face interaction that we know is so valuable. So how might we support environmental law judges to build networks in a virtual setting? Next slide, please. So when you look around and you consider how other experts have come together and learn The concept of masterclasses has been around since the mid-1800s. Indeed, Franz Liszt was the first person to give masterclasses, and virtuoso magicians came to his classes to share ideas in a group setting. It's a little hard for judges to play their instruments, so to speak, but what they can do is we can share seminal judgments from around Asia and the Pacific, and we can allow small workshops of judges in breakout rooms to discuss these seminal cases, so learn about them and network. So the three key goals that we see for this Judicial Masterclass program is, firstly, the idea of interactive judicial learning and networking. Secondly, the capacity to go for an in-depth analysis of watershed Pacific and Asian environmental and climate change cases. It's where you can ask those questions. How did this happen? How did those remedies come about? How did you manage standing? How did you manage the constitutional claims? How did you manage the issue of, is this a policy matter, or is it something that is within the remit of a court? And thirdly, an idea of digital content creation. As we've said, ADB, UNEP, and USAID have worked closely with judiciaries over the last decade, and we each do programs with judicial training academies in countries, and it's always great to have content for those courses. So part of what we do with this Judicial Masterclass program, we can replicate in country with judiciaries, but I'll explain more about which digital content, because the workshops themselves are covered by Chatham House rule and therefore won't be shared. Next slide, please. Let me talk more about what a typical masterclass will look like. So which aspects would be taped and which aspects would be not offline, but Chatham House rule. So for each masterclass, we would have opening remarks, of course. And what we would do is we would film two judges talking about two seminal environmental or climate change cases from different jurisdictions. We would start with screening a pre-recorded interview with Judge 1, who wrote a seminal case. And that would be the digital content that we can then use in other judicial capacity building programs. However, it is not publicly available. It is only available for judges. The second, then we would go to a live Q&A between the judge and the masterclass participants to talk about the case. The next thing we would do is we would screen a second video, a pre-recorded interview with another judge talking about a similar case on similar issues, followed by a live Q&A between the judge and session participants. We would then go to small breakout rooms with up to 10 judges per breakout room, potentially smaller. The idea for this is that it would allow judges to workshop the different cases with facilitators, but also the judges who have been interviewed and are participating in the masterclass. We will then come back into the group for a moderated group discussion. So the idea again is that the judges who participate, who do the pre-recorded interview, would both be there live to answer questions and participate in the masterclass. We would then go to closing remarks. So the next slide, please. At this point, we are looking at piloting 4 classes only. And the idea for the pilot is to simply test if it works. Do judges find it useful? And is it something that we can replicate in the future? So we have come up with a number of different themes that we are interested in exploring in these 4 different judicial masterclasses. And the first idea would be judicial review. So looking at practices and remedies in judicial review matters. The second topic would be looking at continuing mandamus orders in environmental and climate change disputes. The third topic would be habitat conservation in wildlife cases. The fourth topic would be procedural fairness and meaningful consultation. So what is required to give meaningful and accord procedural fairness to communities when we're doing permitting. The next topic would be sentencing and evidence in environmental crime and managing expert evidence. We frequently hear from judges that it can be really challenging to either find experts or to manage the expert evidence that they give. So it would be really valuable to hear from other judges how they managed the use of expert evidence in seminal cases. We are also interested in looking at judicial responses to SLAPP suits and how environmental defenders can be protected. It's such a critical issue in Asia. And lastly, upholding the rule of law for high-profile infrastructure cases. So what are the different elements and the different considerations in such cases? And what I will do after this is we'll go to a poll, because we are interested in actually hearing from people who are present at today's session about different topics that they think would be important to cover in this initial judicial masterclass series of 4 classes. Okay, so moving to the next steps, which is the next slide, please, Angelo. The next steps, obviously, we seek some feedback on people who are here and present in this session today about topics that they think would be relevant. The next step then is to also speak to some of the judiciaries that we work with. We're obviously interested in understanding what topics are useful and how we can support judiciaries in their daily job. So they will know what topics are important for them. Next, we need to reach out to judges of seminal cases and create the content. We need to do the interviews. And rather than doing a presentation, we're actually interested in doing interviews with judges. Of course, they will present on the case, but to ask them questions about how they managed particular aspects of their case. It's just so much more interesting and more interactive in an online learning format. And then we will look at rolling out 4 judicial masterclasses this year, maybe into next year, so that we can test the concept and see how it works. So that's it. That's the summary of what the judicial masterclass sessions would look like. And next, what we would like to do is start a poll. So if Angelo can start the poll, I have no idea how to actually instruct you. So thank you so much. So you can either access this either on whatever device that you're using it on. Please, we'd be very interested to hear from the 102 participants who are watching this session about which masterclass topics you think are important for judges to cover for environmental law and climate change law in Asia and the Pacific. So we'll leave this open for a few minutes and watch it come in. And what I'll do actually, I'll just remind all participants the different options in front of us. So the first one is judicial review practices and remedies. So of course, judicial review is often around permitting decisions. Secondly, the use of continuing mandamus orders in environmental and climate change disputes. For anyone who participated or listened to session 8 today, we talked more about some of the remedies available in climate change and environmental law disputes. In particular, the use of continuing mandamus remedies to ensure that the court can keep a matter open and require the party members to come back to the court and advise on their progress with implementing court orders. The third area is habitat conservation in wildlife cases. This is such a critical area, and we've had some new cases that have come from all around Asia. We have, the Black Panther case from Thailand. We have habitat protection cases from PRC, but we also have some new cases from India and Pakistan that recognize the rights of species, the right to life, and what implications that has for habitat conservation. Fourthly, there is procedural fairness and meaningful consultation. This is something, again, that we talked about in the last session. If we are going to talk about climate change adaptation and what that looks like for communities, what are the rights of communities to participate in consultations? What are their right to participate in planning, and how might courts manage litigation in response to those issues? The fifth one is sentencing and evidence in environmental crime and managing expert evidence. Again, what I didn't say before is the issue of sentencing can be really challenging. How do courts find the right sentence? How do they balance that? Are there sentencing guidelines? It's always useful to hear from other judges. And then how do they manage expert evidence? Lastly, second last, judicial responses to SLAP suits. So there's been recent litigation in the Philippines around how environmental defenders are protected and what constitutes a SLAP suit and who might avail of those protections. And then lastly, upholding the rule of law for high-profile infrastructure cases. Sorry, I'm just getting a message. So I think I'll just leave that poll open for just a couple more minutes. Georgina is just reminding me that if you have any other ideas, please do feel free to put those in either the Q&A or the chat. And please also feel free to email Georgina, Lloyd, me, or Peter Collier. Our email addresses are on the last slide of this presentation so that you can provide other ideas. And I think we might close the poll now. Team, do I need to close that? And we can share the results.
So Briony, I'm now just displaying the results. I'm not sure if you can see them on your side.
I can. Thank you so much. So thank you so much to all the participants. The clear winner seems to be judicial review practices and remedies. But actually, what I am seeing is that the topics are reasonably split, and they do seem of interest to many people who are here. So thank you so much for that participation. So what I might do is just to finish my presentation, Angela, if you could just show the last slide of my presentation that has the email addresses and contacts for the Judicial Masterclass program, which is, oh dear, it's hard to read, the last one, which is my email address, Georgie Lloyd and Peter Collier. Do feel free to reach out to us with any other ideas. So I think that's it for me. And over to you, I think, Georgie.
Thank you, Briony. So if there are any judges in the audience who would like to reach out to us to provide an expression of interest, either to attend the Judicial Masterclass series, or if you would be interested in presenting on a landmark case that has been before you, please do reach out to us. We would be delighted to hear from you. So this brings our session on the launch of the Judicial Masterclass series to a close. Thank you very much again, Christina and Briony. I have not seen any questions that have been put down in relation to what has been presented. Maybe I will wait 2 more minutes to see if there are any questions that are raised. Otherwise, we can bring it to a close. We have received a question. Thank you very much. The question is this Masterclass series for judges only, or are there possibilities for others to join the program? This series is designed for judges, and the pedagogy, the teaching approach that we are using is that it is designed as a small group session for peer-to-peer learning amongst judges. So it will only be open for judges at this stage, but we do run other capacity building programs for other legal stakeholders. And whenever we run those, we will advertise them and share knowledge about them so that others can join. Briony, do you want to add to that?
Sorry, I'm having clicking issues. Yes, just to reiterate, it is only for judges, but ADB does have another program that Matthew Baird also heads up, which is working with educators, legal educators. And so, you know, if this masterclass is something that works well, you know, it could be rolled out in other formats, but it's really a concept that we're trialing now for judges, because the reality is in 2022, we've all shown that virtual networks and virtual learning environments work. What we are just trying to do is innovate and make them more interactive. So if it is a modality that works well, then I'm sure that ADB and UNEP could work on this in other contexts as well. So thanks, Georgie.
Thanks, Briony. And I also acknowledge the comment that is in the chat about considering opening the masterclass for staff of judges who do research for judges. So yeah, that's a very interesting and an important point as well that we will consider. Thank you. So if that is the last question, there is also a suggestion that we have received, Briony, to include test cases around the carbon majors in the masterclass series. Also a very good idea.
Yeah, thank you so much. We'll take note of that.
Great. Well, thank you so much for joining us for the launch of the Masterclass series. The next session and the last main session of the conference is session 9. This is on environmental courts and procedure. Please do join the last session, which begins at 2 p.m. So you have time now to go and grab a cup of coffee, tea, a glass of water, stretch your legs, and then head into the last session at 2 o'clock.
Sorry, Georgie, I see we have a hand up.
Yes, I see that Matthew, I think, has raised his hand. Matthew, would you like to?
I think the last session is not at 2 o'clock.
Oh, it's at 4 o'clock.
4 o'clock, yeah.
Indeed,
So,
it is. You have much more than 15 minutes. You have a couple of hours and 15 minutes to stretch your legs and grab multiple cups of coffee. And then we will see you at 4 p.m. For session 9 on environmental courts and procedure. Thank you all once again, and we'll see you a bit later.
Thank you all.